Get started again.
All right, so back on the record, we were in the middle of the city's presentation.
Well,
We took a break for,
a review of
yes,
this. Just for the folks that are, I mean, Ms. Bennett who's online, do you have this on your computer that you can? So, sorry, take a picture, email?
I mean, I can email it. Okay. You want me to explain it? Is that what you're asking?
Yes.
Gonna make it take all 4 hours. I get to.
Well. Actually, while we're waiting to do that, and I should have done it earlier, but I just let Stephen jump right in, but I just wanted to ask Stephen, what his current position is with the city of Tampa.
Yeah, so I'm a forest examiner with the city of Tampa. I've been here for about 2 years now.
And what did you do prior to that?
Prior to this, I worked at Hillsborough County for 4 years. My first 2, I spent as an environmental code enforcement officer. And then the following 2, I spent as a commercial landscape plan reviewer. And then during that time, I also became certified arborist, on tree risk assessment qualified, as well as 3 certifications in code enforcement and processing that way, as well as a stormwater maintenance inspection, so fencing, barricades, and things like that.
Do you have any prior employment experience prior to Hillsborough County?
Prior to Hillsborough County, I attended the University of South Florida, and I got my bachelor's degree in the University of Environmental Science and Policy with a minor in criminology.
All right, thank you.
Yeah, firewall. Or do you want to follow?
yeah, just 1 second. Did you have any comments regarding today's? Okay,
These exhibits here, exhibit
yes, 4A.
exhibit 4A. No, I believe not at this time.
Okay. Yes, sir.
Mr. Reister, you heard Ms. Johnson-Velez talk about the hardship criteria that's involved in the variance.
Correct.
You're familiar with that criteria?
Correct.
It should be applied in cases where a variance is being sought to remove a grand oak tree, correct?
Correct. The reasonable reconsideration criteria.
You were present at the hearing below in front of the board in October of last year,
That is correct.
and were you present for the entire hearing?
That is correct.
And did you hear the board render their decision at the end?
That is correct.
And when, are you familiar with who Mr. Feldman is?
I know he is a board member.
Do you recall him being the most active speaker when they were deliberating?
Correct.
And did you hear him say at the beginning of his deliberation that they were not under the hardship criteria?
So how it is interpreted, and Susan can correct me if I misspeak, is
So the question simply is, did you hear Mr. Feldman say at the beginning of the deliberation that they were not under the hardship criteria?
they're under the reasonable reconfiguration
Well,
criteria.
no, wait, sorry. The question is, did you hear Mr. Feldman say that? Do you recall him?
I do
saying
not
that?
recall.
All right. You'd indicated before that you're a certified arborist.
That is correct.
Okay, and the tree in this case is classified C8, right?
Correct.
Is there, Ms. Boyes asked you about some bright lines, and I want to ask you about a bright line on tree classification. Is there a bright line on tree classification where it's considered hazardous if it reaches a certain criteria?
Correct. So, C8, better preservation quality, C9 and higher, the tree is considered hazardous or can be.
All right. So 1 point higher in this one would have not even required Mr. Lupin to even appear before the board. He could have removed it as a matter of right.
That is correct.
And you indicated when you were doing your review, you were assigned to this as the city's, for lack of a better term, representative to do the analysis.
Correct.
And you'd indicated when you were reviewing Mr. Lupin's application that you looked not just at lot 109, but all the lots as a whole, correct?
Correct, because that's how it was.
I understand. Regarding, and I know that you'd indicated that there would have to be some additional work done, some air spading done to really dig into pun intended, the root system on the tree. But I want to ask you, as best you can, given your experience and training and your qualification as a certified arborist, is it a fair statement to say that it is likely that there are going to be trailing roots on the south side of that tree that are beyond the 20-foot radius to support the tree link?
So what we use for the 20 feet, I'll explain that first and then I'll answer your question.
Sure.
Is that's kind of the industry standard for tree preservation. So root pruning can occur outside of that. We do allow 5-foot encroachment in certain situations. But I feel like there will be some trailing roots that go outside that 20 feet. How substantial? That part is the $1 million question right now that we're talking about. Are they going to be 3-inch roots? Are they going to be 1-inch roots? That part we don't know without the airspace. And then we also have to take in consideration the trunk development has also been occurring at the same time as the root development. So the wood structure of that trunk is going to be different than what we see in a typically upright tree. Probably, I'll try to describe it the best I can. If you're looking at this tree with its lean, I like these pictures as well. So say this tree with its lean, if this tree was cut, what you're going to see is the growth rings on this inner side are going to be much closer together compared to this tree on this backside. So the tree on the backside may have a 1/2 inch spacing between rings. The rings on this side might be 1/16 of an inch, 1/8 of an inch. So it's going to be drastically smaller to build up the wood structure to support that side of the tree. In case, something does happen to the roots. Trees are living, they're dynamic, they interact with the surroundings. So that's one way they've kind of almost put in like a safety for themselves. Hey, my roots might get damaged, but I got 20 extra layers of wood on this side to help support that, just in case.
Let me take it back to college for a second.
Yeah.
You're familiar with the idea of, fulcrum and a lever, a moment around a particular point.
Correct.
All right. And so that principle basically says if you take a fixed point, in this case, it would be the trunk of the tree where it goes into the ground, and you have a certain mass protruding out on one side, you have to balance it on the other side or else it tips, correct?
Correct.
And then looking at the design alternative 2. Okay. This design alternative 2 essentially presupposes that you'll be able to prune roots all the way up to the 20-foot radius, correct?
Correct. And that is our standard that we use to determine that the tree is effectively not heavy.
Understood. But with this, I'd like to focus on this particular tree though.
Correct.
It is unique. And with the lean going north, or kind of northeast, I guess. And if there is, in fact, I think we testified, there is likely going to be some roots outside that 20-foot zone. The question is, are they prunable?
Correct.
This alternative design 2 hinges, at least the building down here hinges on there being either no roots beyond that, which I think is unlikely, or prunable roots beyond.
Correct.
And we're not going to know the answer to that until, we're not going to know the answer to that until we can get further along in the process, frankly, pretty much during construction, unless we did a level 3, which I understand is not that. Is that correct?
Correct.
All right. Then looking at design alternative 1 and 2, there's a building that's proposed on the north side of lot 109, approaching a little bit onto 107.
Unfortunately, I have an override from my son.
Do you need to take it?
No.
That's quite all right. Let me know what you're thinking.
Let me, I'm sorry.
Susan's forwarded to that. With the attachment, if you could just follow the attachments.
Yeah.
Okay.
He's a plasma physicist. And he's telling you his defense date is moved to April 3rd. Like, yeah, in New York.
Good luck.
In New York,
Where?
Columbia.
I was almost a plasma physicist at Columbia, but
That's when you talk about physics.
That's an entirely different thing.
All right,
All right, may I continue?
certainly. And can I see? Okay, you're talking about alternate one at this point?
Alternate one, I was talking about alternate two in my previous planet factory,
Okay,
and now I'm talking about the. All right, so if you look at alternate one and alternate two, the northerly building, depicted on 109 and 107 is within the 20-foot radius. So you would need to get an exception to come within 5 feet in order to build that.
Yeah, use suspended floors.
Fair enough.
And so on.
But putting aside the root radius, the current tree overhangs where those two, where that 3-story building would go, correct?
Correct.
And you cannot build a 3-story building within 24 feet, can you?
No.
You're not a construction guy, but I
No.
think it's pretty obvious. Okay. And so that would have to be pruned. Do you know whether or not the tree could be trimmed, I should say, trimmed back far enough to be able to accommodate that 3 foot?
So there are some upper canopy. It would be a lot like you referenced the 25%. That's accurate. So he can prune 25% of the canopy for elevation purposes. I know that first limb was at 24, like we talked about, because it was hanging over that existing structure that was there.
When you say the first limb was at 24, I think it's the trunk that measures up to 24. Am I wrong?
So to me, I was basing his report off this limb right here.
Understood.
Yeah, the lowest. So that's at 24 feet.
Mhm.
So if that, say that limb was removed, that takes away this whole portion of the tree, and you would have a higher elevation.
Wonderful. And I think you testified, I'm sorry, go ahead.
But would it accommodate a 3-story building at 35 feet? Right?
35 feet, yes.
That-
Probably not.
We would have to do a more detailed.
Oh, and so, and you said, and I completely get this, but let me confirm, as far as whether or not that's a practical solution vis-a-vis somebody actually purchasing it, insuring it, you don't have an opinion one way or the other.
I
Would you agree then that the alternate proposals 1 and 2, which the board looked at and to some degree rendered their opinion on, presuppose a lot of things, such as, can you put the northerly building in due to the overhang, and can you put the southerly building in due to the potential for a root system that extends beyond the 20 feet?
Correct.
And the last thing I want to ask about is so I think you said if you keep an oak tree, a grand oak, you automatically get certain variances on your setbacks, correct?
That is correct.
And I think we are in agreement that the side yard setback's only a foot
Correct.
each side, right?
Correct.
And then for the rear yard, I think you said up to 40%. Are you positive about that number?
Correct.
Do you have a site for us at all? Because I recall saying 10 to 25.
I will find that note for you, but it's 25 front, 40 rear.
40 rear. With that, that's all.
I just had a couple of other questions for Stephen. So, Stephen, there's been a lot of questions about insurability of a structure or post-development. Is that something you take into consideration?
I do not.
Is that a co-consideration
It is not.
for a branch removal through the variance review board?
It is not.
And there were also questions about mitigation trees, or is that a consideration under the code for a variance request to remove a grant tree?
So we assign the mitigation to make the board aware, but it's not a consideration that I took. Overall.
Okay, and it's not a code requirement.
It is not.
Okay. And then I believe you've already stated this, but you said that you recommended a root evaluation,
I did.
but one was never provided to you.
Correct.
And that would have been something that you could have maybe taken into consideration had it been provided.
Yeah, that is correct.
Okay. I don't have any questions, any further questions.
I do have a little follow-up.
Briefly, we need to give the parties.
The request for the phase 3 assessment that happened after the RP, correct?
That is, so I think it happened before and then again after. Steve and I had a lot of phone calls, I think, during this process, kind of walking them through some different things. I know the roots were brought up. I know Steve and I talked about the roots, and I did recommend the bubble free.
Before the hearing?
I want to say I recommended it both times, before and after. Because if the roots, if the roots were evaluated and something drastic did come up, it changes the situation.
At any point in time, did you tell Mr. Lupin over the telephone that based upon the work he had done, that you would support the grand tree removal?
I did not.
All right. I always appreciate when the hearing officer or judge asks the parties, attorneys, if there are any documents we forgot to admit before we close out and go to the other parties.
No.
All right. Very well. Ms. Bennett, can you hear me?
Yes, I can. Can you hear me?
Yes. Are you ready to provide testimony?
I am.
Would you raise your right hand, please? Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Okay. My name is Carol Ann Bennett. First, I want to thank you for allowing me to speak remotely. I'm on vacation out of state, and I would have been there in person otherwise. I also want to state that I've been taking notes through all of this. So I apologize if I sound a little bit disjointed. I will try to be as coherent as possible. The legislation in the city of Tampa to protect grand trees has been in effect for 40 years. The petitioner knew that when they purchased the property.
I do not believe it. Confident testimony.
You can address that later. Let's hear from the witness, please.
All right. The protections for the grand trees are nothing new. They've been in effect for a very long time. They were in effect when the property was purchased. Ms. Johnson-Velez did a VRB workshop where she explained the criteria for removing granting a variance. She said it's a very established law, that people are guaranteed reasonable use, not highest and best use, not whatever they want. If this petitioner wanted to build 8 townhomes of a particular size, then they needed to purchase land that would allow 8 townhomes of this particular size. This property they purchased does not. If you want to build 8 townhomes of a particular size and you purchase property that won't accommodate it according to the laws or rules or codes of the city, that is the very definition of a self-created hardship. You cannot then say, oh, look, I can't build 8 townhomes of this size on this property. It's a self-created hardship. I also want to point out that the city refers to units. Units is one dwelling unit. It can be a 400 square foot studio apartment. It can be a 6,000 square foot single family home. The code allows how many units. It does not say they have to be, that they are automatically allowed townhomes. They could build, or anything of a particular size. They could build apartments. They could build 8 condos. They could build a combination. They could change the square footage. These properties would accommodate 8 units if they are of the right size and for configuration, which is reasonable use of the property. If they only want townhomes and they only want them of this size, then they can build fewer. That is still reasonable use. This tree is preservation quality. It is protected under the code. It is protected by the grand tree. The VRB unanimously denied the petition. The city staff said that it was not reasonable, that it was not consistent to use this. A lien of this type is not unusual for a live oak. It is the strongest, hardiest trees in the state. And as he and Mr. Eister pointed out, they grow accordingly to support. This sort of lien is not unusual. These trees will live for centuries, even supported on one size. I heard Mr. Mitchell refer to physics. Well, Frank Lloyd Wright and many engineers build things all the time that to look at them, they don't look like they should stand up, but they are built in such a way to support something very heavy, even if it looks like it defies logic. And that's the way these trees grow. They talk about building underneath the canopy. You don't have to build underneath the canopy, or you can build something shorter underneath the canopy. I want to point out that I looked on the property appraiser's website, and for 109, the property appraiser's website says that it's 56 feet by 128 feet. That is a square footage of 7,168 square feet. The tree needs a 20-foot radius. So let's say for the entire 56 width of the lot, you didn't build anything on 20 feet on either side. That's 40 feet by 56 feet that cannot be built on. That's only 31% of the property that is being taken out of the equation. That means that 69% of the property is buildable, not 21% as he stated. I'm not sure where he's getting these figures. I'm getting my figures from the property appraiser's website. I'm also a little dismayed that it seems like they want to go back and forth by saying they submit something.
Ms. Bennett,
Yes.
we need to hear what your factual testimony is,
Mm-hmm.
and not argument about evaluating what you heard, if you don't mind.
Okay, my
I'm
factual
here to
test.
take your evidence. I'm here to take your testimony and the facts that you have for evidence, respectfully.
All right. The facts that I have is that this lot can be built on 69% of it, according to the property appraiser's website. I believe that's reasonable use. The hardship is self-created. The zoning for this lot is for 2 units. That's all that's allowed. If you want to isolate this lot, you can only put 2 units on it. Yet their site plan shows 4 units on it. So on one hand, they want to isolate it. On the other hand, they want to consider it as the whole. And so I'm saying, according to the zoning, they are allowed 2 units. And even if they don't build on 40 feet by 56 feet, they can still fit 2 units. They can be apartments, condos, townhomes, whatever. There is no surprises in their purchase of this property. There's nothing they did not know when they purchased this property. The value of a property is what can be built on it. Can you build a strip club on it? Can you build an apartment complex on it?
Ms. Bennett, I'm going to stop you there again. This is a little bit different than a city commission hearing.
Okay.
This is an evidentiary hearing. So, please give us your facts. I've written down the facts and any other evidence you have, and try not to repeat your argument, okay?
All right. I believe I've given you the facts that it is reasonable use and it is buildable, and that the VRB was correct. And so is Mr. Eister.
Okay. And
Thank
I'm going
you.
to ask, thank you. And I'm going to ask the petitioner and the respondent attorneys if they'd like to cross-examine you, turning to the petitioner first.
Yes, please. Ms. Bennett, can you hear me okay?
Yes, I can.
Ms. Bennett, have you ever opposed or have you ever agreed to the removal of a non-hazardous live oak tree within the city limits?
A non-hazardous,
I think it's.
Grand plot. I want to clarify what you said. You're saying please ask your question again. Are you asking me what I've testified to, or I'm not so sure what you're asking me?
Have you ever appeared before the board and agreed to the removal of a grand oak that was non-hazardous? Or supported the removal?
Just for the record, the city objects for relevance.
Your response?
It goes to her credit. I'm about ready to show the fact that literally on the same day, she agreed to the removal of a healthier, better tree than this one. And I think that there's an agenda.
All right, I'll allow.
So you have in fact agreed to the removal of a healthier tree than the one at issue in this case. And in fact, you did that just a couple of hearings before this hearing in October, didn't you?
First place, this hearing was in October. And I don't know what you're talking about. I'm not aware of what you're talking about.
You don't recall showing up at the board hearing in October, the same session where this was heard. And there was a live oak with a DBH of 34 inches, canopy measurement of 63 feet by 65 feet, and condition of C6 that you supported the removal of.
Oh, is that the one? Tell me what the address is.
I don't have the address in front of me, but it was, I would assume you would, oh, I'm sorry, it is 2912 West San Rafael Street.
Yes, I remember that. I was going to oppose that, and I called Mr. Eister to discuss it with him, as I normally do. And he told me that the tree was now hazardous. I don't know if the rating changed, but he told me that the tree was now hazardous and that they could get the tree removed under the hazardous criteria of the city. The problem with that was that that delayed their construction for 2 years. But he said the tree was now hazardous and it met the criteria for the hazardous tree removal. And so, yes, I did support the removal of that tree based on Mr. Eierster's expert information that he gave me.
Okay, but at the hearing, the tree was presented with a condition of C6, which you would agree is well short of being hazardous, correct?
I'm not sure what was and wasn't said at the hearing. I can tell you right now that if the tree was in fact C6 healthy, I would not have approved it. I supported it because Mr. Eister told me that it was a hazardous tree and it was not C6, that it was below the preservation quality and would qualify for hazardous tree removal. That is the reason I supported it.
Okay, you're saying you don't know what was said at a hearing that you went and supported the tree removal of?
Okay, I think we've plowed this ground. If you have anything else
I have nothing.
on your testimony? Okay. So, okay. All right. Thank you, Ms. Bennett.
Thank you.
I believe we have one more party.
Yes,
And can you state your name for the record, please?
sure. Pamela Jackson Haney.
I'm sorry, Pamela
Jackson
Jackson.
hyphen Haney, Haney.
And can you give us your title and
Sure. I am a member of the Tampa Tree Advocacy Group.
all right, would you raise your right hand, please?
Sure will.
Do you swear or affirm that the testimony you are about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
All right, if you kindly provide your testimony,
Okay.
and I'll give you the same instruction that I had to give Ms. Bennett. This is an evidentiary hearing,
Mhm.
so if you have facts to provide for the record,
Mhm.
please do so.
Okay.
Limit commentary and critique. We're not at a public hearing at City Commission.
Right.
There's a difference. all
Okay.
right?
Thank
And
you.
you will be subject to cross-examination by one or both counsel.
Okay.
Okay, please proceed.
So I was at the VRB hearing, held in, I think, October. I'm losing track of time here. But, I did speak at that hearing also, but I wanted to urge you to accept, the VRB's unanimous decision to save the healthy tree, which was rated a C8 or is rated a C8. As has been stated before, the fact of the matter is, the purchaser or the developer is only guaranteed reasonable use of that parcel. And he knew that the tree was there, obviously, when he bought the property. So this is a self-created hardship. I think the developer could be creative. If he doesn't want to have townhouses, he could build apartments or condos instead. That was stated by the Tampa Heights Civic Association also. They and then another one of their citizens were hoping they could be creative to save this tree, and that is in the record also. Or if he wants to stick with the townhouses, obviously he can build fewer. The other thing I can say is, and this is a fact, and I can give you my address also. I also have a tree, and I stated this at the VRB, that is leaning quite considerably. It's the same, also rated a C8. I've lived at my house for 30 years. I've had arborists look at it regularly. It is a healthy C8. It has been healthy for 30 years. And I've always continuously had property insurance at my home. And that those are all facts. And if I need to provide documentation on that, I can. But we urge you, and another fact is, the reason we're here is we don't have an agenda. I mean, I guess our agenda is to save Tampa's trees. That is a fact. Because of the latest tree report that came out, factually stating that our canopy is dwindling. We're now at only 30%, which is considered critical. And that's what our agenda is, to save Tampa's trees. And that's why we take time out of our schedules to fight for Tampa's trees. And that's it.
Thank you. Cross?
None.
Cross?
Nothing, Steve.
All right. Is there anything further before we conclude? The evidentiary portion, that is.
Nothing from the commissioner.
Nothing, Steve.
All right. I think we can go off record and we can talk about post-hearing matters, logistics, et cetera.
We just stop the, well, I
Yes.
guess I need to continue the recording if this is.
Oh, that's true. We're not in
Okay.
court. I keep forgetting. Right. Sorry about that. All right. So under the code, parties are not required to submit closing argument or provide closing argument today. If you'd like to, I'm happy to hear it. If you want to submit it in writing, I'm even happier to have that.
I'd rather do it orally, but
Okay.
Are we precluded if we?
No.
Should we have this now?
You may do oral today. You may also submit written, which would be my preference, if you submit something in writing.
I will. I'm reading it loud and
All
clear.
right.
You know, this is all very present. I'd like to get a few thoughts out. today if I
Absolutely.
can.
All right. And then before we do that, let's talk about your code requires a recommended order within 15 days, I believe.
15, I believe it's 15 working days.
Oh,
15 working days.
okay. So let's talk about how long you need after hearing to submit a written closing. How long you would like.
I'll defer to my learned co-counsel.
I just confirmed that that's the good time frame. Yeah.
What I'm suggesting is we can go beyond the 15 if we can stipulate. I think it takes us, if it's calendar days,
15 working days
okay.
at the close of the hearing. So
For us to submit or for her to render?
Well, you have to submit, and then I'm gonna suggest we go 15 from that for me to do the
I think
recommended.
I think that's
Typically what's done.
15 working days to submit a recommended order.
Correct. And I'd like to start the clock on the 15 days from when you both agree to submit your written closing. So how long do you need for that?
I think 10 working days.
10 working days from today. All right. And then on receipt, we'll calendar 15 days from that,
And was that working days to submit any
recommended order.
and closing?
And written.
And
Yeah, 10 working days from today to submit written closing. Which I think, I don't know what that is, but whatever date on the calendar that is. Then I'll have 15 days from that to submit a recommended order.
Working,
That's acceptable to the parties.
15 working for you as well.
Yes. All right, let's proceed to closing argument position.
So let me start at kind of a 60,000 foot. I guess I fail to understand the efforts that are being undertaken to save a tree that is one classification away from being hazardous, for which the looping folks that is removed without a permit, that is severely leaning, cuts down. I understand what Ms. Bennett said. With all due respect, the property appraiser's website is almost never accurate. We got our measurements off the survey. And I'm sure she didn't take into account setback lines. So, you know, we're left, and again, with all due respect to the moving of the setback lines that I think would move the needle to some degree, but not a great amount. With a lot here that can only be built in the back, only be built on 22% of the area. And even if that were to be done, there are major concerns about access running a driveway under this hanging tree, or any other structures, um, um, it is going to be a bit of a nightmare. As we discussed, the tree in and of itself, even with the 20-foot radius, is problematic enough. When you take into account the overhang and canopy, that adds another layer of dimension. And then, as Mr. Eister had indicated, it's very reasonable to believe that there will be roots that go beyond that 20-foot radius behind the tree or to the south of the tree. I understand we don't know whether or not those can be pruned or not, but given the size of the tree, I'm skeptical about that. So what we're looking at here is not a situation, and I urge you, Ms. Boyes, to understand that, we were caught in this kind of no man's land here where we had to show the proposal, which included 3 lots, not just the one, because that's what was being proposed. But the analysis has to be confined by rule to the lot itself. It was the only lot that was submitted for approval. It was the only lot that should have been studied and discussed. And when you have somebody saying, whether it be Ms. Bennett or the board or whomever, saying, well, it's going to be 6 instead of 8, what you're doing at that point is you're looking at something beyond the scope of the lot itself. And that's why I keep trying to draw everybody's attention back to the lot itself and just the very unique and kind of unbelievable characteristics that are part of it. Regarding, I want to draw your attention to a couple of other things that you're going to see in the YouTube video, and I'm happy to submit with my written submission some pinpoint sites to the actual timing of the video. But I would like you to review Mr. Feldman's comments afterwards. Mr. Eister didn't recall it, but I think you're going to hear clear as day that at the beginning of the deliberation, he said you're not under a hardship standard here. That is patently wrong. It is a patent misinterpretation or misapplication of the law, which would render the board's action null. For that reason alone, you should find that the board did not take action pursuant to the code. Secondly, even if we get past that major hurdle, the idea that is that it has to be a reasonable reconfiguration, and there are standards on it. Mr. Lupin testified without dispute and without contradiction that he cannot make those reasonable reconfigurations work. Putting aside the legal part, again, we kind of pull out a little bit. We talked about the practicalities of actually building anything on this lot beyond essentially a shed in the back. It's going to be very difficult to do. With respect to the nice folks over at the Tampa Tree Alliance, again, I do respect what they do, but I do question their motives. You will see, and I will provide you with the pinpoint sites, that there was a presentation that day on a C6 tree. There was no mention of it now being hazardous. There was no mention by Ms. Bennett or Mr. Eister about it being hazardous. It was presented as a C6. It is a better tree, a straighter tree than this tree, and for one odd reason or another, the advocacy group got behind its removal. I think that we should take that into consideration. If you're going to consider their testimony, I think we should take that into consideration. With respect to the self-created hardship, I included in your folder and in Ms. Johnson Velez's folder this case of City of Coral Gables versus Erie. I'll cite it since we're on the record. 383 Southern 2nd 1127, 1980 case decided by the 3rd District. One thing I heard Ms. Velez Johnson say that I think is very true is that there's very little current law on this subject because a lot of it had been settled years ago. So this is a 1980 case, and I'm just going to read it. And again, I know you have a copy of it, but just so it's fresh in everybody's mind. In this case, the city contended that an alleged hardship was self-created, thus precluding relief because the plaintiff purchased the property in its present configuration with the knowledge of the already imposed building restrictions. Much like was argued today, we purchased it knowing the tree was on it, so it's his fault. However, that case says we do not agree with this position. Unlike the situation in each of the cited cases, the hardship involved here arose from circumstances peculiar to the realty alone, unrelated to the conduct or to the self-originated expectations of any of its owners or buyers. It goes on to say, in this case, since it is not the act of the purchaser which brings the hardship into being, it is incorrect to charge him with having created it. And then lastly, it says the self and hardship doctrine does not apply. Self and both hardship doctrine does not apply. As we indicated in this other case, when neither the owner of the lot at the time of adoption of the ordinance nor the subsequent owner did anything to create the condition for which the variance is sought, a right to relief possessed by the original owner passes to the successor entitled Such right is not lost simply because the preceding owner bought or contracted to buy with knowledge of the restriction. This is not a self-created hardship by law. So if we're going to talk about whether it's a hardship or not, it obviously is, not just because I get the point that's being made over here. You're trying to maximize financials. Mr. Lubin admitted, yeah, of course I am. I'm a developer and a contractor. Of course, nobody's hiding. But it goes well beyond that. And I think we've shown you today that the hardship isn't just about maximizing financials. It's the fact that you have a privately owned residential lot in the middle, smack in the middle of a planned residential community that simply cannot be meaningfully built on with this grand oak tree in place. I respect the efforts of the Alliance. I respect the city. I think that we should try to maintain as much oak as we can. I get it. But this one, unfortunately, is one that is just, to me, obvious that it needs to be removed because it's not serving or it is creating a hardship here that cannot be removed.
You're welcome.
Thank you. So CA tree, I think we've heard testimony today is preservation quality tree. Maybe it's a point below, but that's what the code provides, right? We have to work within the confines of the code. Under the city's tree code, we have some conditions under which the appropriate board can grant a variance for a tree removal. And the appropriate board in this case was the variance review board. The variance review board is well aware of its authority and that it can only grant variances in cases where they expressly find that there's a practical difficulty or unnecessary hardship. In order to reconcile those two things, the fact that the variance review board is the appropriate board in this type of case, the hardship is determined by whether or not the property can be reasonably reconfigured. It's the only way to reconcile those two things. Have to determine hardship from something. And in a tree removal case, can I reasonably reconfigure my property? I think that the alternative site plans that were shown at the board hearing, we reviewed them today, in addition to the new site plans that were admitted as composite exhibit 4 today, show there are several different ways in which this property can be reasonably reconfigured. All of them, well, the two site plans that we have today show even a site plan that's even more in compliance with other aspects of the city of Tampa code. We have the front facing lots. But again, they put the maximum number of units on this property without regard to the tree. So it's not just, and I get it, and I appreciate Mr. Lupin. He testified at the VRB hearing that I'm trying to maximize my number of lots. I'm trying to maximize my profit, my financial return on this property. And that I have a hardship of if I can't maximize, but that's not what a legal hardship is under Florida law. I do have a number of cases here myself, which I'm happy to provide, but there are any number of cases where Florida courts have found that financial hardship or an economic advantage doesn't constitute a hardship sufficient to warrant the granting of a variance. I've got Dade County.
I can save some time. I will stipulate that a financial hardship standing alone is not sufficient to benefit.
So with that stipulation, there's no grounds for the variance review board to have granted this variance. They're not authorized to grant a variance short of finding a hardship. In this case, the board found that reasonable reconfiguration is possible, as demonstrated by the alternative site plans. There were viable options, is what the VRB found, and it's not necessary to maximize all of the units on this property in the fashion that the developer has proposed. That was the basis for the denial. It was in keeping with not only the city code, but with well-established and longstanding Florida law on this topic. And the VRB's decision was appropriate, and for that reason, the city is requesting that the hearing officer affirm the denial of this variance. And after examining all the evidence.
All right. Anything further from the parties? Ms. Bennett?
Not from me. Thank you.
Okay. Ms. Bennett, any closing comments? Very briefly?
Just briefly, they knew they couldn't build this when they bought it. They can build something smaller, the same number of units, reasonable use.
Thank you
Thank
so much.
Can I make a statement?
Not really. We're done.
Let me ask one housekeeping matter. Do you want a page limit on the system? Like, I don't want to go call one. 5 pages, enough?
Whatever it takes, 5 to 10. I don't want 100.
That's what I'm trying to.
And then, just for everybody, the code section that was referenced with the setback reductions, so everybody could look at that, it's 27-156, table 4-2, footnote 7.
All right.
I know that's a lot.
I'm gonna ask somebody to send me a copy of that. All right. Okay. We are concluded off the record. I thank you for your diligence. Everyone was well prepared. And I look forward to your written closing argument this coming.
Very happy to. Thank you.
Thank you.
Thank you.
Everyone.
Safe travel.
Thank you.
Leave it.